We're set.
We're good? Okay. Are these on? All right. Good morning, everyone. We'll go ahead and get started. My name is Jennifer Ashton. I'm the magistrate for the town of Ocean Ridge this morning. I'm going to start by explaining how the process is going to go. We're going to call the cases as they appear on the agenda. If you have come to today's hearing, your case will be called before the people that have not come. Luckily, there's only 2 cases, so.
Yes.
Are both respondents here? Or?
No, it's my understanding that Mr. Stearns, unless there's someone here on his behalf, he had sent a letter that I'll show you, Your Honor, after, when we get to that case, but I think only Mr. Vliet will be here.
Okay, great. So we'll when we call the case, we'll call your case first, sir. The town will give me its evidence and testimony first. You'll have an opportunity to ask the town's witnesses any questions that you have about process or about photos taken, and then you'll be able to tell me what's going on with your property. Once I've heard everything, I will enter a ruling, and we'll talk about timeframes to come into compliance and any other part of the requested order from the town. You'll get a written order in the mail, maybe about a week from today. I've got to go back and prepare it after this hearing. But again, if you have any questions as we go through the process, please feel free to ask them. All testimony this morning does have to be under oath. So if you're going to be speaking on a case, you don't need to stand. Just raise your right hand for me and I'll swear you in. Okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? I do. All right, thank you. And town, you can go ahead and call your first case.
Yes, we would like to go with case number 2, Special Magistrate, the Gregory Van Vliet case, which is violation hearing case number 2019-01. And first, Your Honor, I would like to show Mr. Van Vliet a copy of the file that I would like to introduce. You can take a look. This is the application that I think you have filed here. That's the application. So this person here is the offense report, just explaining what the violations are that the official method. Let's see, can I put this up here if you don't want me to show you up here, if you want to come up here and look side. Okay, so that's the offense report showing, here's the violations that they found that Wayne will get into and that I think he had talked to you about as well. And then the violation, the code sections, and then pictures of your home. I think that's the door there. Let me see. And that's the allocation sheet, just the amount, the administrative hearing fees that we'll be getting into later, depending on if she finds guilt, and well, that's just the agenda. So that's it. That's what we have. Do you have any objections? Your Honor, I'd like to introduce this into the record.
Okay.
The town's file.
Okay, let me take a look real quick. Did you want me to just mark this as like a composite exhibit 1?
Yes, Your Honor, if you could,
Okay.
that would be great.
Okay. Well, hearing no objection, I will admit these documents into evidence as Town's Composite Exhibit 1, and I'm going to go ahead and make a finding that notice is good and sufficient for today's hearing. There is an affidavit of service by posting in the file, and it worked because you're here. I'm going to ask the code enforcement officer to just tell me a little bit about what's going on at the property first, and then I'll turn to you, sir, and you can tell me what's been happening as well.
Yes, Your Honor, Wayne Cameron, the building official, will be the one
Okay.
testifying as to the violations and I guess the violations of the code.
Okay, go ahead. Tell me what's
Good morning,
happening.
Your Honor. Wayne Cameron, building official. I've been previously sworn in. This is a violation of not only the town code ordinance, but the Florida Building Code. We've got from the pictures, and Mr. Van Fleet's testimony will confirm that we've got a second floor door opening that goes to nowhere. That occurred because the staircase was previously removed. We've got water damage, and he's trying to work through the process. He also had applied for a permit back in November, which has not been approved. He has the comments from November as well, that he needs to get plans that reflect the scope of work, architectural designs, as well as a contractor to do the work, so a permit can be issued. To date, as of this date, this has not happened. So that's why this case has been brought before you.
Okay, but a permit was applied for. He got plan comments back. They just haven't been responded to, and that's why we're here.
And that's why we're here.
Okay.
We're trying to get compliance, Your Honor, so that we can remedy this unsafe situation that we have currently.
Okay. And you need the plans because you need to understand the full extent of the work. I mean, you can see a little bit from the outside. I'm looking at the photos. You're right. The staircase has clearly been removed and looks like some fill-in of the exterior wall there. But,
Right.
okay.
And that's a two-story structure, so that second floor door, if someone was to open from the inside, it goes nowhere,
I understand.
besides somebody falling.
Okay. All right. And do you want me to hear from the property owner first, and then we'll talk about a recommendation on time?
Yes, Your Honor.
Okay. Good morning, sir. Could you tell me your name first?
Good morning. Yes, regarding this,
And you are the property owner?
I'm the property owner. I'm Gregory Van Fleet, yes.
Okay, go ahead.
Okay. Yeah, this has been an ongoing thing for a long time. It's the attempts to get a competent licensed, in some cases, contractor has been very difficult. The main thing being is the nature of the job. Most of the shell contractors and stuff, nobody will touch it. I had a family friend that did roofing for years and stuff, but he wouldn't do the build out. So you run into the gambit here. I want to do the whole roof and get everything fixed. The first thing is to eliminate that, the flat roof structure, which created the problem, and complete the roof out, and then address the wall structure, and then rebuild the staircase. But the staircase was removed in part just to to have access for the scaffolding so they can do the job. And at the end out, the staircase was 40 years old, so.
It probably needed
it
to
was
be
time for
replaced
it to
anyway.
come down.
Would
So
rot and
that,
whatnot.
but one takes place with the other. You have to start at the top first and then address the other issue, and at the final touch, then come back out with the staircase.
Okay.
Plus, I was gonna put a new hurricane door up there too. So the architecture of I have an architect, and actually, as it works out, it's the husband-wife team. Now, the wife is an architect. She's got a GC. She's got a roofing license, and
That's what you
the
need, a
husband-
GC, so we're good. We're moving, okay. That's
yeah,
what they were
the
asking
husband
for.
is a GC. He's got the roofing. He's got mode license and stuff like that. So
Okay,
it's a pretty good mix, but still slow.
sure.
It's been agonizingly slow for the whole process. That's been ongoing and stuff, and frustrating and depressing. I mean, the whole gambit goes along badly.
Okay.
But,
Well, let me turn to the building official. You've been out to this site and you've seen the scope of work
Yes.
from the exterior at least. What is the town's recommendation today on time frame to get that permit issued?
The town will be comfortable with allowing Mr. Van Fleet another 60 days to get into compliance. I'm turning it over to him if that's enough time for him to be able to accomplish that, but due to the nature of what we're getting into rainy season. He has water intrusion, and the structure itself, if it continues to be in this state, will continue to deteriorate.
Okay, let me just confirm, because each city is different, what do you want for compliance? Like, what do you actually require? Is it just the permit issuance, or is it the work being finished, or?
We would be requesting give him 60 days to have an approved permit
Okay,
issued by the town.
got it. And then we would kick him into the Florida Building Code, and he'd have his full
Correct.
6 months and his inspections on a routine basis
That is
and all of that.
correct.
Okay, we'll go over that in more detail in just a minute. Okay. And so 60 days to have the permit issued by the town,
Right,
approved
Johnson.
permit issued by the town. Are you all seeking a fine in the event that that does not happen?
Yes, we would be seeking a fine of $50 a day.
Okay. And let's see, 60 days out. And I'll turn to you just a minute, Mr. Van Vliet, just to make sure that you understand everything that they're talking about here. Let's see what 60 days out would be. So your April code enforcement meeting is on April 2nd. So that means probably he would have to have the permit issued by the end of March to make that April meeting?
Yeah.
Okay. If I were to set compliance for March like 28th or 29th, would you be able to go out and inspect before that April 2nd hearing?
I will.
Okay.
Well, I don't know, is it so much of an inspection or just whether or
See
not
if it has a-
paper-wise
Oh, you're
we've
right.
issued
Just,
the
it hasn't been
permit?
issued.
Yes.
That's right. Thank you for clarifying that. Okay. Okay. All right. So what they're recommending to me, I like to give a specific date instead of saying 60 days, so everybody's on the same page as to when things are supposed to happen. But March 29th is pretty close to 60 days from today. So what they're asking for is to have an approved permit issued by the town by March 29th, or there would be a $50 a day fine that would start running if you didn't have that done. To get the approved permit, your architect team and your GC, they would come in and they would address all the plan comments that the building official has. And once all the plan comments are addressed, then the permit would issue. But when there's still plan comments outstanding, obviously they can't issue the permit. So your team would come in and you'd meet with the building official and get that all taken care of by March 29th. Or that $50 a day fine would start running. Tentatively, the fine assessment hearing would be set for April 2nd in the event you didn't get the permit issued. And the town's also asking for their costs today in the amount of $414.67, which I saw in the file. Now, the question for you is, 60 days from today, March 29th, do you think that that's a feasible date?
Actually, given what I've been going through, I would say no at this point. The build out for the roof, he hasn't got back to me with the requested changes and stuff for the first part being the build out and the wall. But that all needs to be done and put in place before they can put the staircase back in. So the staircase, I could say, possibly being delayed if he can't get the structure completed in time. He can't put the staircase because it's gonna
Well,
impede
and this is why I was asking the questions I did, all they're asking for you to get done by March
the
20th
permit,
is the
yeah,
permit. So
yeah.
then you'll have 6 months from the date that permit's
Okay,
issued
okay.
to get all the work done.
All right.
The building official was just giving you some testimony about, water intrusion and rainy season. Hopefully that'll get your
Yeah, well,
contractors
that-
moving a
that
little
would
faster for
been
you.
the whole goal, to try to get the stuff done during the
Okay.
dry season, so be it,
Okay.
because of the nature of the work.
So really, at this point, it's administrative plan review, addressing comments. The work doesn't even you can't really start until you get the permit. But,
Right.
so that's the 60 days. Do you think that that's going to be,
I don't see a problem with that as long
Okay.
as these people work. I've been through
Okay.
a whole bunch of them, a
Okay.
big bunch.
okay. So we'll go with the 60 days for right now. So as I said before, notice for today's hearing was good and sufficient. I'm going to order compliance by March 29th, 2019, or a $50 per day fine will be imposed, and that will run until compliance is achieved. And then the fine assessment hearing will be set for April 2nd, 2019. And I'm imposing the town's costs for today's hearing in the amount of $414.67, and that will be paid within 30 days from today's date. That's the typical timeframe. And is there anything further on this case?
Not from the town.
Okay. All right, sir, thank you. Stay
All
in
right.
contact with the building official, and hopefully you've got a good team
Get
with
it
you
done
now.
this time. Thank you.
All right, thanks a lot. All right.
Hi, now we're on case number 1, which is Aaron Stearns and Barbara Villa. I will give you the file in just a second, Your Honor. I do want to point out a couple of things in it. We did receive a letter from Mr. Stearns where he had stated he was not able to attend. However, he is recognizing that, okay, he's going to confirm as of April 1st, 2019. We would like, that's nice of him saying that. However, this is February. We would still like a 30-day time frame to come into compliance, but and anything after that, then we will be asking for a fine in that amount. Also, in the incident report, and Officer Chobin. Is that how you pronounce it, Chobin?
Yes.
Okay, Officer Chobin can testify as to some of the things in the prior history of this property that shows there have been numerous calls, numerous complaints. This is the first one that we've actually been able to get some testimony from the person who was staying there who said, yes, I am renting it, and it is under
Got
30
it.
days. So
Got
we
it.
can
Thank
do
you.
that.
Perfect. Okay. Let me just read the property owner's letter real quick before we get started. Is it, okay, so he says in here he did register the home as a rental. Is that part correct?
Yes, and so
Okay.
section
What is it, 30157A?
30-157A is no longer a violation. They're in compliance with that section. It is just 64-1C3, which is the zoning district of the town that says no vacation rentals. And in your backup, you can see vacation rentals is a minimum of a 30-day period.
Okay, thank you.
And I would also like to point out, too, we have the affidavit for service in there as well.
Okay, thank you. And I see in the property owner's letter, he admits it's on Vrbo, which is a vacation rental website. Okay, got it. Okay. All right, let me just go through the file real quick. So I've got the letter from the owner, I've got the affidavit and notice of violation, the affidavit of service by posting, incident reports, victim witness affidavit.
Which also points to the gentleman who
Got
had
it.
said, yes, I stayed here and it was only for a short period of time,
Got it.
not the 30-day period.
Okay. All right, got the code sections from the town ordinances. Property appraiser printout showing the owner, certified mail receipt that was signed by the owner. Cost recovery of $328.67. Okay, all right, you want this admitted into evidence?
Yes, I do.
I'll admit, since the respondent is not here, I will admit all of the town's exhibits into evidence as composite exhibit 1, and now I'll turn to the officer, and you can tell me what's going on.
All right, good morning, Your Honor. My name's Officer Chobin. I am the primary code enforcement officer for this case. Starting in September 7th, 2018, up until, I believe, a few months ago, either myself or Officer McAllister had over 17 contacts with the property or the property owner. Basically, each time we were getting anonymous calls that families were staying at this location for usually about a week, which is obviously in violation of the town code, which we previously named. When I would make contact with the homeowners or McAllister would make contact, basically the people staying there would tell us that they were friends of the family and they weren't renting.
Okay.
This contact happened several times. However, all of the families were from different parts of the country, Canada, Indiana, Florida, all kinds of places like that.
Okay.
Which led me to believe that, they knew very little information other than the owners' names, that they may have been coached possibly by the homeowner. So after having made contact several times, we spoke with James Damaris,
And that's the one that signed that affidavit for you?
correct, on December 27th.
Okay,
And once again, he initially told us when I made contact, or told me when I made contact with him, that he was a friend of the family's and he wasn't renting. When I let him know that this was an ongoing issue, that we had been to this property several times, we've been told the same things by different people, and also that at one point we had seen that the homeowner had the property listed on websites such as VRBO and Trivago and some other rental websites, that we believe that they may have been coached and that they could possibly be involved in a hearing if they were lying. So we were wondering if they were truthful. And when we said that, basically Mr. Damaris said, to be honest, I did rent the property. I rented it on VRBO, and we asked if he would be comfortable with signing a sworn written statement, at which time he provided, which is in the case file.
right. Saw that.
And he essentially said that his family used the VRBO website to rent the unit at 5501 North Ocean Boulevard. He was told by the owner that they were guests of the house. He rented the house for approximately 1 week, and he paid approximately $2,000 for that 1 week period. He also provided an email back and forth with the owner, Aaron Stearns, showing that he was there for 8 nights, December 24th to January 1st.
Okay.
And, Your Honor, what we are looking for is a finding of guilt on this. We aren't looking for a fine of something that has occurred, but in my conversation with the chief, I would like to correct something I'd said before. Given the nature of this, the numerous complaints that we have received, I think it's in the CAD file there in front of you. The gentleman certainly he's in compliance now. He doesn't need any more time to come into compliance. We would like effective from the date, from the order, the date of the order, that any other violations, it will be treated as a repeat violation with up to a maximum of $500 per day fine.
Okay.
So that's really what we're looking for, and along with the cost, the administrative cost to be paid.
Okay, so what I can do, I can set it up, I call them finding of fact orders. They were in, they were in violation, they've since come into compliance. However, any future violations that are proven at a hearing would be subjected to the repeat violation fine amounts, which would be $500 per time that it's seen, so per day that it's seen or witnessed. So that's kind of along the
Yes.
lines of what you wanted. And then
That's what we're looking for.
the administrative costs.
Yes.
Okay, so let's go ahead and do that. All right. Before, no one had anything else, right?
No,
Okay. Okay.
that's it from us.
Yeah, and I'm looking at the codes here. It's clearly, a vacation rental is defined as being a period of less than 30 days duration. Your code for vacation rental prohibition has been in place for years, long before that 2011 preemption, so you are good to go on that. Okay, so I'm going to make the following findings of fact and conclusions of law. I'm going to find notice is good and sufficient. There was an affidavit of service by posting and a signed certified mail receipt in the file, and there has been actual contact with the property owner. He did send a letter to the town dated January 22nd, 2019. I'm going to find that the property has come into compliance with section 30-157A. Did you want that as a finding of fact as well, or did that come in
I think
time?
we can just remove that out because he complied with that before we brought it in front of
Got
you.
it.
So he's already gotten that, so that's okay.
Okay. The property was also in, or was in violation of section 64-1C3. That's right, yep. However, it has since come into compliance, but compliance was not achieved within the time stated in the notice of violation. Therefore, I'm entering a finding of fact order, which means any future violations could subject the property owner to a repeat violation fine and hearing. And I'm going to impose the town's cost for today's hearing in the amount of $328.67, and those are to be paid within 30 days from today's date. Okay, anything further?
No, ma'am.
No,
Right.
that's all.
Oh, and I needed to adopt the minutes. Did I do that at the beginning? Thank you. Every town is different. I will adopt the minutes from, I think it was December 5th, 2017, and I'm approving those. All right, thank you very much. We're adjourned.
Thank you.